Welcome to episode 33 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Oliver v. City of Brandon. The case was decided March 20th, 2026. And as always, we'll start with the syllabus. Petitioner Gabriel Oliver is a street preacher in Mississippi who believes that sharing his religious views with fellow citizens is an important part of exercising his faith. His vocation sometimes took him to the sidewalks near an amphitheater in the city of Brandon, where he could find sizable audiences attending events. In 2019, the city adopted an ordinance requiring all individuals or groups engaging in protests or demonstrations at around the time events were scheduled to stay within a designated protest area. In 2021, Oliver was arrested for violating that ordinance. He pleaded no contest in municipal court. The court imposed a $304 fine, 1 year of probation, and 10 days of imprisonment to be served only if he violated the ordinance during his probation. Oliver did not appeal, paid the fine, and served no prison time. Because he still wanted to preach near the amphitheater, Oliver filed suit against the city in federal court under 42 U.S.C. Section 1983, alleging that the city ordinance violates the free speech clause of the First Amendment by consigning him and other speakers to the amphitheater's protest area. The complaint seeks, as a remedy, a declaration that the ordinance infringes the First Amendment and an injunction preventing city officials from enforcing the ordinance in the future. In other words, the relief requested is only prospective. Oliver seeks neither the reversal of nor compensation for his prior conviction. The parties contested in the lower courts whether this court's decision in Heck v. Humphrey, which prohibits the use of Section 1983 to challenge the validity of a prior conviction or sentence so as to obtain release from custody or monetary damages, bars the suit from going forward. On the city's view of Heck, a person previously convicted of violating a statute cannot challenge its constitutionality under Section 1983 because success in the suit would cast doubt on the prior conviction's correctness. On Oliver's contrary view, Heck does not apply when a plaintiff seeks wholly prospective relief rather than relief relating to the prior conviction. The district court agreed with the city's understanding of Heck and found Oliver's suit barred. The Court of Appeals for the Fifth Circuit affirmed on the same reasoning. Held, Oliver's suit seeking purely prospective relief and injunctions stopping officials from enforcing an ordinance in the future can proceed, notwithstanding Oliver's prior conviction for violating that ordinance. Heck does not hold otherwise. Part A. Before the court's decision in Heck, the city would have had no plausible basis for claiming Oliver's suit is barred. That type of suit falls within Section 1983's heartland. Assuming a credible threat of prosecution, a plaintiff may bring a Section 1983 action to challenge a local law as violating the Constitution and to prevent that law's future enforcement. In Woolley v. Maynard, the court held that rule to apply even when the plaintiff was previously convicted under the challenged law. The court explained that because the suit at issue sought wholly prospective relief only to be free from prosecutions for further violations, and was in no way designed to annul the results of a state trial, Section 1983 provided an avenue for the plaintiff's claim. Were it otherwise, the plaintiff would have been trapped between the Scylla of intentionally flouting state law and the Charybdis of foregoing what he believes to be constitutionally protected activity. The court's decision in Woolley, taken alone, would defeat the city's attempt to prevent Oliver's suit from going forward, but the city argues the court's later decision in Heck requires the opposite result. In Heck, the court held that a state prisoner could not use Section 1983 to seek damages attributable to his allegedly unconstitutional conviction. The court reasoned that such a suit in truth mounts a collateral attack on the validity of the conviction and thus intrudes on the habeas statute's domain, and such a suit could lead to parallel litigation and conflicting judgments about the same conduct, with the Section 1983 suit suggesting that the plaintiff should be released even as criminal or habeas proceedings found the opposite. Hence, the so-called Heck bar on Section 1983 damages actions that necessarily require the plaintiff to prove the unlawfulness of his conviction or confinement. When a state prisoner seeks damages in a Section 1983 suit, the court went on, The district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction or sentence. The court subsequently drew a line between Heck-type claims and those seeking forward-looking relief. In Edwards v. Balasuk, the court held that while a state prisoner could not obtain damages for an alleged past violation, a claim for prospective injunctive relief, the use of fairer procedures in the future, may properly be brought under Section 1983 because it does not depend on showing the invalidity of a previous sentencing decision. In Wilkinson v. Dotson, the court allowed state prisoners to bring a Section 1983 suit requesting an injunction requiring the state to comply with constitutional parole requirements in the future, determining that such a claim for future relief was distant from the core of habeas and so not barred by Heck. Part B. As in Balasuk and Dotson, Oliver's suit falls outside habeas's core, and likewise outside Heck's concerns. Oliver is not challenging the validity of his conviction or sentence for the purpose of securing release or obtaining monetary damages. Instead, he seeks wholly prospective relief, only to be free from prosecutions for further violations of the ordinance. Because Oliver's suit does not, as habeas suits do, collaterally attack the old conviction, it cannot give rise to parallel litigation respecting his prior conduct and does not risk conflicting judgments over how that conduct was prosecuted or punished. Unlike in Heck, Oliver's suit merely attempts to prevent a future prosecution, so the Heck bar does not come into play. Part C. The city's main argument to the contrary rests on one sentence in Heck that states, quote, "When a state prisoner seeks damages in a Section 1983 suit, the district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction or sentence. If it would, the complaint must be dismissed." End quote. Strictly speaking, the necessarily imply language fits. If Oliver succeeds in this suit, it would mean his prior conviction was unconstitutional. But general language in judicial opinions should be read as referring in context to circumstances similar to those then before the court, and the circumstances here differ from those in Heck. The Heck language at issue was used to identify claims that were really assaults on a prior conviction, even though involving some indirection. By contrast, there is no looking back in Oliver's suit. Both in the allegations made and in the relief sought, the suit is entirely future-oriented, even if success in it shows that something past should not have occurred. The Heck court did not consider such a suit, and the Heck language was not meant to address it. Heck, properly understood, does not preclude suits that only attempt to prevent future prosecutions. Oliver's suit to enjoin future prosecutions under the city ordinance so he can return to the amphitheater may proceed. Justice Kagan delivered the opinion for a unanimous court. Petitioner Gabriel Oliver was once convicted of violating a city ordinance restricting expressive activity near a public amphitheater. He now wishes to return to that venue to voice his beliefs, but this time without the threat of criminal punishment. He therefore filed this suit alleging that the city ordinance infringes the First Amendment. The suit, brought under 42 U.S.C. Section 1983, seeks an order declaring the ordinance unconstitutional and preventing its enforcement in the future. The suit, in other words, requests only forward-looking relief, nothing to do with Oliver's prior conviction. The question presented here is whether the court's decision in Heck v. Humphrey bars Oliver's suit. The answer is no. Heck prohibits the use of Section 1983 to challenge the validity of a prior conviction or sentence so as to obtain release from custody or monetary damages. That decision has no bearing on Oliver's suit seeking a purely prospective remedy. Part 1. Oliver was convicted some 5 years ago for violating the local ordinance he now challenges. Oliver is a street preacher in Mississippi, a Christian who believes that sharing his religious views with fellow citizens is an important part of exercising his faith. His vocation sometimes took him to the sidewalks near an amphitheater in the city of Brandon, where he could find sizable audiences attending events. Oliver was apparently not the only speaker attracted to that area, and the activities there caused some disruption. In 2019, the city adopted an ordinance requiring all individuals or groups engaging in protests or demonstrations at around the time events were scheduled to stay within a designated protest area. On his next trip to the amphitheater in 2021, Oliver checked out that area but found it too remote for communicating his message, so he returned along with his signs and loudspeaker to the sidewalk fronting the amphitheater. And there he was arrested by the Brandon police chief for violating the city ordinance. The next month, Oliver pleaded no contest in municipal court. The court imposed a $304 fine, 1 year of probation, and 10 days of imprisonment to be served only if, during his probation, he again violated the ordinance. Oliver did not appeal, paid the fine, and served no prison time. Because he still wanted to preach near the amphitheater, Oliver's next step was to file this lawsuit in federal court, naming the city and its police chief as defendants. The suit is brought under Section 1983, which authorizes claims against state and local officials for the deprivation of any rights secured by the Constitution. Oliver's complaint alleges that the city ordinance violates the free speech clause of the First Amendment by consigning him and other speakers to the amphitheater's out-of-the-way protest area. The complaint seeks, as a remedy, a declaration that the ordinance infringes his and other speakers' First Amendment rights and an injunction preventing city officials from enforcing the ordinance in the future. Footnote 1. Originally, Oliver also sought damages for the city's prior enforcement of the ordinance against him, but he abandoned that request as the suit progressed, leaving only the above-described pleas for declaratory and injunctive relief. Carrying on. In other words, the relief requested is only prospective. Oliver seeks neither the reversal nor compensation for his prior conviction, and Oliver has since made clear that he has no interest in using a favorable judgment in this suit to later get his record expunged or avoid his conviction's collateral effects. The suit is just meant to ensure that Oliver may return to the amphitheater to speak without fear of further punishment. The parties contested in the lower courts whether this court's decision in Heck v. Humphrey bars the suit from going forward. On the city's view of Heck, a person previously convicted of violating a statute cannot challenge its constitutionality under Section 1983 because success in the suit would cast doubt on the prior conviction's correctness. On Oliver's contrary view, that rule is subject to two limitations, either of which enables his suit to proceed. First, Oliver contended, Heck does not preclude a suit seeking wholly prospective relief rather than relief relating to the prior conviction. And second, Oliver argued, Heck does not apply, regardless of the relief sought, when the person suing was never in custody for his conviction, so never had a chance to challenge it in federal habeas proceedings. Footnote 2. The premise of Oliver's second argument is, of course, that he had not been in custody following his conviction. That premise appears to be wrong. Under his sentence, Oliver served a year of probation, indeed, was still serving that time when he filed this suit. And a person on probation is generally in custody for purposes of federal habeas corpus. For whatever reason, though, the city failed to raise that objection below, and both lower courts accepted that Oliver was not put in custody for his conviction. Given that the case has proceeded so far on that basis, we treat any contrary argument as forfeited and proceed in the same way. Carrying on. The district court agreed with the city's understanding of Heck, and the Court of Appeals for the Fifth Circuit affirmed on the same reasoning. If Oliver's Section 1983 suit succeeded, the district court reasoned, the judgment would undermine his municipal court conviction, and so the suit was categorically barred under Heck. Similarly, the Fifth Circuit viewed Heck as precluding any Section 1983 claim that, if successful, would necessarily imply the invalidity of the plaintiff's criminal conviction. Oliver's claim, the court maintained, was of that sort. If he showed that the city ordinance violated the First Amendment, he would also show that his prior conviction should not have happened, and that fact, the court concluded, was dispositive. It did not matter whether Oliver's conviction had landed him in custody. Nor did it matter whether Oliver's suit sought only prospective relief. The Fifth Circuit denied rehearing en banc, but 8 of 17 judges dissented. Those judges understood Heck to bar only the retrospective use of Section 1983 to collaterally attack criminal convictions. A suit like Oliver's for prospective injunctive relief, the dissenters argued, is not precluded because granting a forward-looking injunction neither invalidates nor imposes tort liability for a prior conviction. The dissenters noted that the Court of Appeals for the Ninth Circuit had adopted their view, which meant there was now a circuit split about Heck's proper reach. We granted certiorari to consider the two independent reasons Oliver offered below for why his suit escapes the so-called Heck bar: that he was never in custody for his prior conviction, and that he now seeks purely prospective relief. We need not address the former reason today because we agree with Oliver and the Fifth Circuit's dissenting judges on the latter. Given that Oliver asked only for a forward-looking remedy, an injunction stopping officials from enforcing the city ordinance in the future, his suit can proceed notwithstanding his prior conviction. Footnote 3. In reaching that holding, we do not say that every person can challenge his statute of conviction through a Section 1983 suit for wholly prospective relief. The government, appearing here as amicus curiae, urges us to reserve the issue whether a person may bring such a suit while he is in custody for violating the statute challenged. We think it appropriate to do so because, as we have explained, our assumption here is that Oliver was never in custody. Carrying on. Heck, properly understood, does not say otherwise. Part 2. Before our decision in Heck, the city would have had no plausible basis for claiming Oliver's suit is barred. That type of suit, as no one here disputes, falls within Section 1983's heartland. Assuming a credible threat of prosecution, a plaintiff may bring a Section 1983 action to challenge a local law as violating the Constitution and to prevent that law's future enforcement. And half a century ago, in Woolley v. Maynard, this court held that rule to apply even when the plaintiff, like Oliver, was previously convicted under the challenged law. For anyone who has followed along this far, a description of Woolley should strike a chord. George Maynard viewed the "live free or die" motto on his New Hampshire license plate as repugnant to his moral and religious beliefs, so he covered those words with reflective tape in violation of a state statute. Maynard was convicted for that conduct 3 times over in state court, receiving mostly suspended sentences involving small fines and short jail terms. After the last proceeding had concluded, and presumably anxious that there not be a fourth, Maynard brought a Section 1983 suit in federal court, seeking a declaration that the state statute violated the First Amendment and an injunction to prevent its future enforcement. New Hampshire argued, as its front line of defense, that the suit was precluded because Maynard has already been subjected to prosecution under the challenged law. Our decision in Heck had not yet issued. Instead, New Hampshire relied on younger principles, which caution against federal interference with state court proceedings. Those principles would be offended, New Hampshire claimed, if a federal court were to enjoin the enforcement of a state law at the behest of someone earlier convicted under it in state court. This court rejected New Hampshire's argument on the ground that Maynard's suit sought only to prevent further prosecution under the New Hampshire statute. The suit, the court explained, was in no way designed to annul the results of a state trial, as indeed would have been troubling under younger doctrine. Maynard had already sustained his convictions and served his sentences, and he did not seek to have his record expunged or to annul any collateral effects his convictions might have, for example, upon his driving privileges. Rather, Maynard sought wholly prospective relief. He wanted only to be free from prosecutions for further violations of the same allegedly unconstitutional statute. Because that was so, the court held Section 1983 provided an avenue to bring his claim. Were it otherwise, the court reasoned, Maynard would have no good way to vindicate his First Amendment rights. He would be trapped between the Scylla of intentionally flouting state law and the Charybdis of foregoing what he believes to be constitutionally protected activity so as to avoid yet another criminal prosecution. All of that could as easily be said of Oliver's suit. Like Maynard, Oliver was convicted under the statute he now alleges to violate the First Amendment. But also like Maynard, Oliver did not seek in his Section 1983 suit to upset that conviction or even to avert its collateral effects. Rather, Oliver sought wholly prospective relief, an injunction to preclude further prosecution under the law he had earlier broken. If not able to bring such a suit, Oliver would face the same untenable choice as Maynard: violate the law and suffer the consequences, the Scylla, or else give up what he takes to be his First Amendment rights, the Charybdis. Our decision in Woolley, taken alone, would thus defeat the city's attempt to prevent Oliver's suit from going forward. Some 2 decades later, though, the court encountered Heck v. Humphrey, which the city now argues requires the opposite result. Roy Heck had been convicted in state court of manslaughter and was serving a 15-year prison sentence. While his appeal was pending, he filed a Section 1983 suit in federal court, naming 2 prosecutors and a police investigator as defendants. Heck alleged that they had committed misconduct, such as destroying exculpatory evidence, to gain his conviction. He sought as a remedy monetary damages attributable to his unconstitutional conviction. The question raised was whether Section 1983 allowed the suit. The court held it did not. The court took as settled that Heck could not have used Section 1983 to challenge the fact or duration of his confinement and seek immediate or speedier release from custody. A claim of that sort, the court noted, must be brought in habeas corpus proceedings. And so too, the court held Heck could not use Section 1983 to seek damages deriving from a conviction unless it had already been overturned. To be sure, Heck could not get damages by way of a habeas action. But in suing for them under Section 1983, Heck was in truth mounting a collateral attack on the validity of his conviction and thus intruding on the habeas statute's domain. Such a suit could lead to parallel litigation respecting the issues of probable cause and guilt, and it could give rise to conflicting judgments about the same conduct, with the Section 1983 suit suggesting that Heck should be released even as criminal or habeas proceedings found the opposite. Hence, the Heck bar on Section 1983 damages actions that necessarily require the plaintiff to prove the unlawfulness of his conviction or confinement. When a state prisoner seeks damages in a Section 1983 suit, the court went on, the district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction or sentence. A judgment for Heck would have done so, for his success rested on proof discrediting his conviction. His Section 1983 suit therefore could not go forward. In 2 later decisions, though, the court drew a line between Heck-type claims and those seeking forward-looking relief. In Edwards v. Balasag, a state prisoner alleged that procedures used in a disciplinary hearing, which had deprived him of good time credits and thus lengthened his sentence, violated his 14th Amendment due process rights. He sought money damages for the alleged past violation. He also sought an injunction requiring prison officials to adopt new procedures so as to prevent future violations. The court made short work of the claim for damages. As in Heck, the court reasoned the prisoner could not obtain damages without demonstrating the invalidity of the punishment imposed on him, i.e., the loss of good time credits, and thus impinging on habeas. But the claim for prospective injunctive relief, the use of fairer procedures in the future, was a different thing. Said the court, ordinarily a prayer for such prospective relief may be properly brought under Section 1983 because it does not depend on showing the invalidity of a previous sentencing decision. Likewise, in Wilkinson v. Dotson, the court allowed state prisoners to bring a Section 1983 suit alleging that existing parole procedures violated the Due Process Clause and requesting an injunction that the state comply with constitutional requirements in the future. That claim for future relief, the court determined, was distant from the core of habeas and so not barred by Heck. The same is true of Oliver's suit. Oliver is not challenging the validity of his conviction or sentence for the purpose either of securing or speeding release or of obtaining monetary damages. Instead, Oliver is seeking, in Woolley's words, wholly prospective relief, only to be free from prosecutions for further violations of the city ordinance. And that request, as Balasag and Dotson recognized, falls outside habeas's core and likewise outside Heck's concerns. Oliver's suit does not, as habeas suits do, collaterally attack the old conviction. It thus cannot give rise, as Heck feared, to parallel litigation respecting his prior conduct, nor does it risk conflicting judgments over how that conduct was prosecuted or punished. The suit, after all, is not about what Oliver did in the past and depends on no proof addressed to his prior conviction. Unlike in Heck, the suit merely attempts to prevent future prosecution, so the Heck bar does not come into play. The city's main argument to the contrary, echoing the decisions below, rests on one sentence of our Heck opinion. That supposedly dispositive line states, quote, "When a state prisoner seeks damages in a Section 1983 suit, the district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction or sentence, If it would, the complaint must be dismissed, end quote, unless the conviction has already been invalidated. Of course, Oliver does not seek damages in his Section 1983 suit, but the city points out that several post-Heck decisions drop the sentence's prefatory clause while repeating the rest. And in the city's view, that modified inquiry suggests that the Heck bar should apply to Oliver's suit. That is because, the city says, a judgment in Oliver's favor would necessarily imply the invalidity of his prior conviction. To declare the city ordinance unconstitutional, as Oliver seeks, would be to imply that no one, including Oliver, should have been convicted under that law. The argument is a fair one, but hardly dispositive. We have to agree that if Oliver succeeds in this suit, it would mean his prior conviction was unconstitutional, so, strictly speaking, the Heck language fits. But that could just show that the phrasing was not quite as tailored as it should have been. This court has often cautioned that general language in judicial opinions should be read as referring in context to circumstances similar to the circumstances then before the court, and not referring to quite different circumstances that the court was not then considering. The city's argument raises the question whether that is true here. We think, with the benefit of hindsight, that it is, that the sentence relied on swept a bit too broad. That language was used in Heck to identify claims that were really assaults on a prior conviction, even though involving some indirection. One example was found in Heck itself, a claim seeking not straightforward reversal of a conviction and release from custody, but damages attributable to that conviction requiring proof that police misconduct made it invalid. Another example Heck offered was yet further attenuated. A person convicted of resisting arrest, defined as preventing an officer from effecting a lawful arrest, brings a Section 1983 action for damages against the arresting officer for violation of his Fourth Amendment right not to be unreasonably seized. The damages sought, unlike in Heck, are not attributable to his conviction for resisting arrest. They are damages derived only from the underlying arrest. Still, a Section 1983 action would not lie because the plaintiff, to prevail, would have to negate an element of the offense of which he has been convicted, i.e., that the underlying arrest was lawful. Once again, the suit requires looking back to conduct involved in a prior conviction and offering contradictory proof. By contrast, there is no looking back in Oliver's suit. Both in the allegations made and in the relief sought, the suit is all future-oriented, even if, as a kind of byproduct, success in it shows that something past should not have occurred. The Heck court did not consider such a suit, and the Heck language was not meant to address it. Proof positive comes from the logical but wholly untenable consequences of the city's position. Suppose that after Oliver's conviction, another citizen brings a Section 1983 suit to enjoin the city ordinance so that he can speak outside the amphitheater. Let's name this citizen Lawrence and say that he boasts a clean police record. Would Heck allow Lawrence's suit to proceed? The very question seems ludicrous. No one would say Heck poses a bar, but under the city's logic it should, because here too Heck's language fits. The hypothetical suit, no less than Oliver's own, would, if successful, necessarily imply the invalidity of Oliver's conviction, as well as all other convictions under the statute. A judgment in that suit, too, would demonstrate, and in just the same way, that Oliver's conviction was unconstitutional. The hypothetical thus shows that the necessarily imply language cannot extend as far as the city wants. Contra the city's logic, the Heck language does not preclude Lawrence's Section 1983 suit because, rather than challenging a prior conviction, that suit only attempts to prevent future ones. And contra the city's actual position, the language does not preclude Oliver's Section 1983 suit for the identical reason, because, as explained above, it looks forward only. With Heck thus out of the way, Woolley returns to center stage. Recall the court held in that case that Maynard could sue under Section 1983 to prevent future enforcement of an allegedly unconstitutional statute despite a prior conviction under that law. The same rule allows Oliver to sue under Section 1983 to enjoin future prosecutions under the city ordinance despite his prior conviction. Were that not so, Oliver would face the same dilemma as Maynard: flout the law and risk another prosecution, or else forego speech he believes is constitutionally protected. We declined to put Maynard to that choice, and we will not put Oliver to it either. His suit to enjoin the ordinance so he can return to the amphitheater may proceed. We accordingly reverse the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. And that does it for the opinion in this case. Once again, unanimous. Once again, seems pretty straightforward. The so-called heck bar is pretty clearly not dealing with as broad a category of suits as that single line that the city relies on suggests. It's not dealing with any and all suits that would necessarily imply the invalidity of a prior conviction, under the challenge statute. Like, it's dealing with suits that intrude into, the realm of habeas relief, where, somebody is seeking money damages or something for a prior conviction. And so, yeah, it doesn't prevent suits that are asking for purely prospective relief. Oliver isn't asking for the prior conviction to be invalidated. He's not asking for damages for the prior conviction. He's not asking for anything relating to the prior conviction. He's just asking that the law be found unconstitutional, or the ordinance be found unconstitutional, that the city be enjoined from prosecuting it in the future, and his conviction and all the effects thereof can stand. He's fine with that. And yeah, that seems right to me. Seems right to all 9 of the justices on the court. I will say I'm not entirely. I'll have to look into this more, but at least on its face, the validity of the heck bar itself seems a little tenuous. I can I can I can understand. I can buy. We generally shouldn't read one statute to kind of intrude into the heartland of another one unless, it's pretty clearly intended to do so. And it's pretty clearly no intention that Section 1983 would swallow the habeas statutes. But when it comes to like suits for remedies, you know, for prior convictions that you couldn't get in habeas, like money damages, I don't know where a bar on that kind of suit comes from. There's no conflict with the habeas statutes. It's a completely different kind of relief, completely different remedy that you couldn't get in habeas. It has nothing to do with seeking compelled release or expedited release or anything like that. Yes, you are attacking the conviction and the validity of the conviction. And so, yes, you might have contradictory results where, under the Section 1983 suit, the court finds, oh, yeah, this was unconstitutional. You're entitled to money damages. Whereas in criminal and habeas proceedings, the court finds, no, this wasn't unconstitutional. You're not entitled to release. I don't see why that can't happen. It's awkward, but I don't see why it can't happen. And I don't see why the text of either the habeas statute or Section 1983 compels a bar there. So, yeah, I don't know. It's something I'll potentially look into more. Maybe read the Heck decision, read the relevant statutes a little more closely, because my memory's fuzzy. But yeah, at least on its face, I'm like, it seems a little dubious to me. But accepting this Heck decision, this and the so-called Heck bar that it spawned, as good law, yeah, it still doesn't get in the way of Oliver's suit here. The court is correct. The court applies it correctly, even if it might not actually be correct. And again, I'm not entirely sure. It's just on its face. I'm like, And then finally, just because I talked about this in the 2 prior episodes, the writing, it's a cake in opinion. It's written beautifully. Much better than the Sotomayor opinion that I complained about a couple episodes ago. So, just thought I'd throw that in there because I've been complaining about the the liberal justices' writing, just to say, "Hey, it's not my biases against the liberal justices. I like how Kagan writes a lot. I don't like how Sotomayor writes. I don't like how Jackson writes." But anyway, with that said, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts. And if you'd like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to bonus and exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we'll continue on through the Supreme Court's 2025 term. Until then.